Okay, good morning. Thank you so much for joining me. My name is Kaitlin Wildoner, and today we are going to discuss Social Security disability claims for knee or ankle pain. That may seem like two very different body parts, and they are, but as you'll see as we go through the listings, there's a lot of commonalities as far as the listings that Social Security looks at when it comes to knees and ankles because they're considered major weight-bearing joints. So before we get started today, I do want to reiterate that this is not considered legal advice. This webinar strictly serves to give a very broad overview of Social Security disability claims as they relate to knee and ankle pain. If you have specific questions, do not put them in the, if you're watching this on the replay, don't put them in the comment section. And if you are with us live, please don't put specific questions in the chat. And the reason is because I can't answer specific questions. Every case is very different. Every case has nuances. And in order for me to properly formulate a response and really, be able to give you educated advice, I need to know about your specific situation. And I don't want you divulging any of your personal information either live today on the webinar or after. At the very end, I will provide my contact information. And that's how, if you do have specific questions, please feel free to shoot me an email, give me a call, and we'll see if we can schedule a time for us to chat about your specific case. But do not leave any personal identifying information or specific questions in the chat on the live webinar or the comments down below on the replay. You can comment kind of other things if you've got other questions or if it's been helpful to you. I always love hearing that. So feel free to leave those types of comments, but for specific questions as they relate to you, reach out to me directly and we can set a time to kind of have that discussion for about 10 minutes or so. All right, so with that out of the way, today we are going to talk about, again, knee and ankle pain as it relates to Social Security disability. Today, we will lead into with Social Security disability basics, which is how I tend to start kind of most of my webinars, because I don't know where you're coming from. If you have a knowledge base on how Social Security claims work or not, but that is always a good kind of ground, setting the ground rules. After that, we will move into the listings. Then we will talk about residual functional capacity. And then finally, I close out all my webinars the same way, which is how an attorney can help you with your Social Security disability claim. A little bit about me. I'm the founding attorney of Beacon Disability PLLC. It's a law firm based in St. Johns County, Florida, and I exclusively practice federal administrative disability law, which means that I can assist clients at their agency level cases. Throughout the United States, there are certain state nuances that might be better served. And we've got kind of contacts in other states that can help with that. But I focus on assisting clients at the agency level cases, which is initial reconsideration hearing, and then the appeals council. All right, getting into Social Security disability basics. As you can see, there's two programs. There's Social Security Disability Insurance, which is SSDI, and then there's Supplemental Security Income, SSI. Both programs require that you be disabled for a period of at least 12 months, which means that you are unable to work, unable to engage in substantial gainful activity for those 12 months due to physical and or mental impairments. Now, where the two programs diverge is with SSDI, you have to have a sufficient number of work credits, which usually means you have to have worked 5 of the last 10 years. There are exceptions to that. That does change. Kind of going back to I can't give any broad brush advice on this webinar, but instead it more serves as a general educational fund of knowledge. So with SSDI, you do have to have sufficient work credits. And like I said, that does vary. But generally speaking, you have to have worked 5 of the last 10 years. And then with SSI, you have income and asset restrictions. So if you are single, the asset restrictions cap out at $2,000. You cannot have more than $2,000 in assets if you're single, and it bumps up to $3,000 in assets if you are married. The income restrictions are a little more nuanced. Social Security does have all of this information on their website, and you can certainly find it. And if you have specific questions as far as the income restrictions, you can reach out to us. Sometimes the best thing to do, though, honestly, is just to reach out to Social Security directly. And if they tell you, nope, you can't apply, you wouldn't qualify based on your income or your assets, they'll let you know that right away. They won't even get to the evaluating of the medical. They'll let you know right away. It's not something that, it's not a path available to you. Okay, so moving on to the 5-step evaluation process. So the first step when Social Security gets that file, if you've made it past their very cursory review of would you qualify for SSDI? Do you have enough work credits? Would you qualify for SSI? Are you below that income and asset threshold? Once you get past that, if the answer is yes to either of those questions, and so you've got your application and it's being processed, they will first then look, are you currently engaging in substantial gainful activity? And in 2022, that is defined as working 20 hours a week or earning more than $1,350 a month in gross earnings. So very low thresholds if you are working more than 20 hours a week or you're earning more than $1,350 a month in gross earnings, then you will not move on to step 2. Social Security will look at that. They'll say, oh, you're engaging in substantial gainful activity and you cannot be found disabled under our rules. And so then they move on. They will deny your case and say you don't qualify. If you are not engaging in substantial gainful activity, Social Security moves to step 2, which is they look to see, do you have any severe medically determinable impairments? If you don't, if you have no severe medically determinable impairments, nothing that's preventing you from working from a medical perspective, Social Security again stops the case evaluation there and they will deny the claim. If you do have at least one severe medically determinable impairment, your case moves to step 3, which is, do you meet or equal a listing? Does your one or more severe medically determinable impairments meet or equal one of their listings? And we'll get into the specific listings, some of them for knee and ankle in just a few minutes. If you do meet or equal a listing, the case evaluation stops. Social Security will say, you are disabled, we have found you disabled. They'll get you that favorable decision out, they'll get you a notice of award out, and your benefits will be turned on and started. If you do not meet or equal a listing, then Social Security creates a residual functional capacity for you, which is what they believe you are capable of doing within physical and mental limitations on a consistent and ongoing basis so that you can return to work. And they will use that RFC, the residual functional capacity, to determine, can you go back to your past work that you've done in the last 15 years, long enough to learn how to do the job. If you can return to your past relevant work, the claim evaluation stops there. Social Security says, you're not disabled, sorry. If you cannot return to your past work, Social Security moves to step 5 and they say, okay, can an individual with the RFC we've given you, can they do any work that exists in the national economy? If the answer is yes, there are other jobs that are available, then you are found not disabled, and that's the end of the 5-step evaluation process. If you can't go back to your past work and you can't engage in any other work, then you are found disabled at step 5. Okay, looking at the listings. As I mentioned, step 3 is, do you meet or equal a listing? And there are 14 broad categories included within the listings, and each listing has medical criteria included in it that applies to the evaluation of impairments in adults. There is also a separate set of children's listings, but today's webinar and most of what I talk about deal with adults because those tend to be the most prevalent cases, are adult cases. So looking at here, the Bluebook categories within subsection number 1, which is where we're focused. Musculoskeletal disorders, our knees, our ankles are part of our joints. So they are part of our musculoskeletal system. And here you can see that there are a slew of listings for back disorders. It does include, like I said, major joints in any extremity. So that does include, like your hips and your knees and your ankles, a non-healing or a complex fracture of the femur, tibia, pelvis, or a different type of bone, and non-healing or a complex fracture of an upper extremity as well. But today we're focused on these lower extremities in our legs, our knees, and our ankles. But as you can see, again, here are the current, as of May 2022, musculoskeletal disorder listings for Social Security. Here's the first listing that we'll look at specifically, and it's listing 1.17, which is reconstructive surgery of a major weight-bearing joint. So as you can see, there are 3 different factors that have to be met in order to meet this listing. In addition to a surgical history, number one, you also have to have an impairment-related physical limitation of your musculoskeletal functioning that has either already lasted or is expected to last a continuous period of at least 12 months. If you're 3 months out from surgery and the doctor's estimating that you'll be able to go back to work next month, those 4 months don't qualify you for disability. There's no such thing as temporary Social Security disability less than a year. You always have to be disabled for a period of at least 12 months due to physical and or mental impairments. So that's why, you've got to have that disability that's either already lasted for 12 months or expected to last. On top of that, you also have to have a documented medical need for a walker, bilateral canes, bilateral crutches, or a wheeled and seated mobility device that involves the use of both of your hands. So essentially, you're seated down all day, and you need both of your hands to move, or you've got to need a walker, bilateral canes, or bilateral crutches. So as you can see, these listing thresholds are pretty high. Not only do you have to have the history of surgery and the documented medical need for an assistive device, but then also impairment-related physical limitation that's expected to last at least 12 months if it hasn't already. Looking at 1.18, which is abnormality of a major joint in any extremity, there has to be medical documentation of all of this. So starting with A, you have to have medical documentation of chronic joint pain or stiffness. You've got to have documentation of abnormal motion, instability, or immobility of the affected joints. And then there has to be an anatomical abnormality of the affected joints noted on physical exam written down by the doctor, as well as imaging. And really that's kind of an or. So if you've got physical exam, but you don't have any imaging, that should be good enough. But for my cases, I always try to tell my clients, we've got to collect as much medical evidence as we can to show Social Security really what's going on, because that's what the whole point is. Social Security cases hinge on medical records. And, I've got some clients that, don't like to get the medical treatment. And I get that. I also do not enjoy going to the doctor, getting poked, prodded, do this, do that. It's expensive. It's frustrating. But it's so important for Social Security purposes, as you can see. And then again, here you go. D has slightly more restrictive requirements as far as those limitations and documented medical need for assistive device. So take that into account as well. Looking at 1.19 is pathologic fractures due to any causes, which is they have to occur 3 separate occasions within a year. So if you've only got 2, don't meet the listing. If you've got 5, you meet the listing, as well as you can also show B, which is the same as last D. You've got to have that functioning impairment that's expected to last at least 12 months, and then the documented medical need of at least one of either 1, 2, or 3, which relates to your ability to use your upper extremities, as well as a medical need for an assistive walking device. 1.20 covers amputation due to any cause. And as you can see, it's amputation of one or both lower extremities occurring at or above the ankle with complications of the residual limb that have lasted or are expected to last for a continuous period of at least 12 months, along with medical documentation that shows either your inability to use a prosthesis and a documented medical need for a walker, bilateral canes, bilateral crutches, or a wheeled and seated mobility device that involves the use of both of your upper extremities, both of your hands. And the reason why that starts with D is because there is an A, B, and C, but this D is the one that dealt with the lower extremities. A, B, and C all deal with other body parts. So that's why we jumped to D, in case you look at it on your own. Okay, and here's more non-healing or complex fractures. So as you can see, there's got to be a solid union that's not evident on imaging and is not clinically solid. There's also got to be impairment-related physical limitation of musculoskeletal functioning. We keep seeing that, lasting or expected to last for a continuous period of at least 12 months. That is across the board. Again, if you are only expected to be out for 6 months, Social Security disability is not the option. Now, I have had clients that are expected to be out 6 months and then wind up not being able to return to work. So that is certainly possible. And if you are in that phase right now, my heart is with you, number one. And number two, if it's not looking like you're able to return to work, if it keeps kind of getting pushed out and you're not able to work and you're getting stressed about finances, go ahead and apply for Social Security disability. Again, you've got to have that impairment that's lasted or expected to last at least 12 months. So if all the doctors, you're 6 months out and, you've got 4 doctors that are telling you you'll be able to go back to work next month on month 7, you're doing great. And then you've got one doctor over here who's like, yeah, I don't know. And you're kind of leaning towards this doctor that's, I don't know. You can always apply for disability. I mean, the worst thing they're going to do is tell you no. And they very well might. If you don't have that medical documentation and the bulk of the medical evidence at this time is showing that you should be able to go back to work next month, but you're not so sure, and this doctor over here is not so sure, you can apply. And if they deny it, and that takes them a couple months to do, and so now instead of 6 months in, you're 9 months in, and you're still not any better. And not only do you have this one doctor over here now saying you're not ready to go back to work, you now have 2 other doctors of your original 4 over here who said, oh yeah, you'll be able to go back to work next month. They're over here now. And so now you've got 3 doctors who are saying, you're right, you're not ready to go back to work. And you've got 2 that still say you do. And Social Security can cherry pick the evidence a little bit and say, well, these doctors, we're going to give them greater weight because of A, B, and C, and we're going to discount these doctors' opinions because of D, E, and F. That can always happen. But again, if it's looking like you're not going to be able to work, you don't have to wait those 12 months to apply. You should wait at least a little bit. If the plan is for you to be able to go back to work in month 2 and, everything is pointing in that direction at 2 weeks out from your surgery, then I wouldn't really recommend applying. But if you're 6 months out, still haven't recovered, and, you and at least one of your doctors are not so sure about that recovery path, it doesn't hurt to apply. And like I said, the worst thing Social Security is going to do is say, no, we don't think you're going to be disabled for at least 12 months. And then, these cases don't resolve overnight. So there's no harm in applying kind of before that 12-month period has expired. Again, as long as the medical evidence is there and helpful, and you don't have all of your doctors saying you should have gone back to work 4 months ago. So something to think about. Okay, so now turning to residual functional capacity, you'll see that there's several different kind of more descriptive, and then you've got heavy and very heavy. At sedentary exertional level, you should be able to lift no more than 10 pounds, and it is considered occasional walking and standing. The light exertional level, you can lift and carry up to 20 pounds occasionally, 10 pounds frequently, with frequent standing and walking. And medium exertional level is being able to lift and carry up to 50 pounds occasionally, 25 pounds frequently, and it requires frequent standing and walking. So those are kind of the 3 most common that Social Security will go with: sedentary, light, and medium. It's important that if you have a doctor that says you can do light work, that they understand that this is where Social Security is coming from, that they're going to read that and say, okay, you can lift and carry up to 20 pounds occasionally and 10 frequently with frequent standing and walking. Whereas your doctor might be thinking, well, no, you've got knee and or ankle issues. You can lift and carry up to 20 pounds occasionally and 10 pounds frequently, but the standing and walking frequently is not a good fit for you. You would be sitting at least 6 or 7 hours in an 8-hour day. So it's important to have a doctor define what they mean within these exertional levels, because everybody kind of defines it a little bit differently. This is how Social Security defines it. All right, so that says RFC and back pain. It should say RFC and knee/ankle pain. And if you have got kind of a doctor that's treating you and is putting in an RFC, they might note that you're limited in your ability to stand, walk, sometimes sit even. That does happen sometimes, especially if you've got to have kind of the knee propped up or the ankle propped up. That's a limitation in sitting. Some doctors don't realize that enough to put it in the records, but it is. It's a limitation in sitting. If you've got to have your right knee or your right ankle elevated at least, waist high, chest high, however high, that might be something you can do at home. It's not something you can do at work. So that's important to include in the medical records, that this is a limitation that you have with respect to sitting, because you've got to have this elevated, maybe not all day, but it's got to be, you can put it down normal for 30 minutes and then elevate for 30 minutes. And then that's got to kind of switch on and off. So that's important to note in the record if that's a limitation that you've got in your residual functional capacity. You might also have limitations in your ability to lift and carry. Of course, in your ability to climb stairs and ramps or ladders, ropes, and scaffolds, certainly in your ability to bend, crouch, and crawl. So those are some of the common RFC limitations that we see with knee and ankle pain. Others can certainly exist, but those are some of the common ones that if you do have limitations, your doctor should be putting that in the record so Social Security can see and understand, oh, okay, now I get it. Now I understand. It's not that they can't sit all day, but they have to sit, but they have to be able to have their knee or ankle elevated at waist height. So that's going to be a limitation we've got to include in their RFC and include when looking at, can you go back to your past work? So think about that. Here we go. Again, have your doctor either complete an RFC form that outlines your limitations or ask them to put them in the record. It's also helpful for your doctor to say why those limitations exist for you. Why do you need to elevate your knee at waist height? Why are you limited to standing only 30 minutes at a time in 1 hour in an 8-hour workday? Why? It's not enough to have a doctor that says you can't work. I see this all the time. I've got clients that call, they get so excited. Oh, my doctor says I can't work. It's a shoo-in for disability. Nope. Not enough for your doctor to say you can't go to work because of your condition. Social Security looks at that as an issue reserved for the commissioner. It's not for your doctor to decide that you can't go back to work. It's for your doctor to treat you. It's for your doctor to decide what your limitations are. It's not for your doctor to say you can't go back to work. That's up to Social Security. So that's why it's important to have your doctor include those limitations in your RFC, in your file, so Social Security can see that and go, this person can't go back to work. All right, how can an attorney help you? So we provide guidance on what correspondence from Social Security actually means. We file necessary appeals. Importantly, we review your medical records in your case file. When we get a file at really any level, but especially the hearing level, we take a look at it right away. And we see, okay, here's what the doctors are saying. I've got a client telling me that my doctor's telling me I can't go back to work. But not only do I not see that in the record, I don't see anything that supports that finding. Social Security is not going to take your word that that's what your doctor told you during your last 7 visits. That needs to be in the record. And as I just said, it needs to be more than Mrs. Smith can't go back to work because she's disabled. It needs to say Mrs. Smith has these following limitations, which would preclude her prior employment and likely preclude all other employment. We would discuss what additional records would be helpful in your case. We review your documents for accuracy and completeness. We talk with you about what Social Security is looking for in their requested forms. And we work with you to provide updates back and forth. We provide updates to Social Security about your claim and then from Social Security back to you about your claim. If you have to go to a hearing before an administrative law judge, we help with that. We prepare you for that hearing, and then we question you and any witnesses during the hearing, including a medical witness or a vocational witness that are present at the request of Social Security. So we do a lot more. That's just some of the kind of basic foundational things that we do. All right. As promised, here's my contact information, telephone number, email. Feel free to reach out, give me a call, send me an email if you have specific questions. I truly appreciate your time today. I appreciate you sticking with me. Please, I would love to answer questions at the end of these, but just because questions tend to be so specialized, I don't. So if you do have questions, if this webinar raised more questions than it answered, feel free to reach out and we can certainly help you as best we can. If it's not something we can help with, we'll try to put you in contact with someone who can. So thank you so much for watching. If you are on the lives, have a wonderful day. If you are on the recording, also have a wonderful day. And feel free to subscribe below, and that way you can be notified when other videos, we put a couple of these out each week, and then the Wednesday webinars do get replayed the week after. So this will be a replay next Wednesday, and then it'll be up there at, as often as you need. So feel free to reach out if you've got any questions. Thanks so much for watching. Take care.